Today's courtroom drama unfolds in Texas, where Mr. Sanchez, already on probation for a third-time DWI offense, faces the possibility of losing his freedom for good. Presided over by a firm and fair judge, this hearing dives deep into repeat offenses, accountability, and one man's struggle between redemption and relapse. With objections flying, legal debates heating up, and the judge holding nothing back, every word in this courtroom carries weight. Will Sanchez convince the court that he deserves one more chance, or is this the end of his road to rehabilitation? Let's break it down.
I'm Sanchez, and Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation, and there was an unagreed. There was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact.
Here's where things get legally complex but fascinating. The defense objects to parts of the pre-sentence report, hinting at possible racial bias and unfair weight on old convictions. But the judge, she cuts through the noise like a scalpel. Her reasoning is sharp. Prior offenses must be reviewed when it comes to repeat DWISB, because it's not just about one mistake, it's about patterns. Notice how she acknowledges the defense respectfully, but stands firm, emphasizing that probation isn't just a free pass, it's a contract built on trust and compliance. Viewers, what do you think? Should judges overlook old mistakes if someone's been good for years?
My decision, I think, as far as what I'm going to do in the case, I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I
Yes.
just wanted to note, for purposes of today that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
This part hits emotionally. The defense leans on letters of support, family, community, friends all, vouching for Sanchez's progress. They argue he's shown 5 solid years of good behavior, minimal violations, and a sincere effort to turn things around. It's the classic redemption argument. Don't judge me by my past. Judge me by who I am now. But in probation court, talk isn't enough. Judges look for consistency, honesty, and change. It's a fine line between rehabilitation and relapse end. That line is about to be tested.
I will, and I did, and let me pull them up again just because I think that's been...
So specifically, they were not admitted for this purpose. They were admitted for bond.
Okay, that's right. Thank
for
you.
purposes of bond.
Okay.
However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
to support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior conviction and the current one for which he's on probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was
Yes.
a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem.
And here it is, the turning point. The judge lays it out, brutally honest. Yes, there was a long gap between offenses, but the cycle started again. She reminds Sanchez and the entire courtroom how lucky they are. This is another DWI and not an intoxication manslaughter case. That statement right there, it lands like a hammer. The law doesn't just punish, it protects. This is the consequence of repeated disregard for public safety. It's not just about what Sanchez did wrong. It's about what could have happened if luck had run out. The sentence, 7 years in state prison. A sobering end to a long chain of chances.
Made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. I'd argue for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the Institutional Division of the Texas Department of Corrections.
In the end, Judge West's decision sends a clear message: second chances have limits. Sanchez's case is a painful example of how repeated poor judgment can outweigh past progress. The courtroom energy shifts from hopeful to resigned as the papers are signed and the reality of a 7-year sentence sets in. This isn't just a story about punishment, it's about public safety, responsibility, and the cost of choices.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement, so you do have some rights to appeal. Once y'all sign that, I'll tear off that bottom copy for y'all if y'all signed at the bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. Let's see. The bottom 2 copies are y'all's if you want to tear those off.
Okay. I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff.
If you found this case as powerful as we did, make sure to like, share, and subscribe for more real courtroom breakdowns. Drop your thoughts below. Was the judge too harsh, or was justice finally served? Let's talk about it in the comments.